We were discussing about High Court judges appointment and jurisdiction powers of the High Court and its judges. For each state, one High Court, and then that High Court has got all powers as a court of record, including the power to punish for contempt one Chief Justice and other companion judges, and the number of strength of the judges is as determined by the President of India. Then President of India appoints the Judge of High Court. The Judge of High Court, he works until he attains the age of 62 years. In case of Supreme Court, 65 years. In case of High Court, till he attains the age of 62 years. So what are the qualifications of a High Court judge to be appointed? If he is not a citizen of India, he can't be appointed as a High Court judge. And he must have another qualification of any one of the two conditions. One is he worked as a district judge for 10 years or as an advocate of High Court for 10 years, whatever it is. In case of a Supreme Court judge, a distinguished jurist also can be appointed as a judge of Supreme Court, though he is not having the degree of law. But in case of High Court, he must be either an advocate practiced for 10 years or judge of court, district court for 10 years. So what we have to see is, in computing the period during which a person has been an advocate of High Court, you must see whether he worked as 10 years as an advocate. Like judicial office means member of tribunal or any post under the union or state requiring special knowledge of law. So we have to see that the person who is going to be appointed as a judge of High Court has completed 62 years or not, citizen of country or not, or practiced as a advocate for 10 years, or worked as a district judge for 10 years. So the salaries and judges and how to appoint the Chief Justice and additional and acting judges, all these things are mentioned in this chapter 5, which deals with the high courts in the states. Then thereafter, we have got a provision of subordinate courts. This is dealt with in chapter 6. We have to see what are the qualifications that must be there for a judge to be appointed in district courts. Chapter 6 of the Constitution of India deals with subordinate courts. Article 233 says, appointments of persons to be and the posting and promotion of district judges in any state shall be made by the governor of the state in consultation with the High Court exercising jurisdiction in relation to such state. So, it is the governor of the state who makes appointment, but he must do it in consultation with the High Court exercising jurisdiction in relation to such state. That is very important. So qualifications, 7 years an advocate or a pleader, and then High Court must appoint that person. So we have understood that district judges are being appointed by High Court. How? It is the governor of the state, not the president of India, who appoints district judges. He will do so in consultation with the High Court, exercising jurisdiction in relation to such state, and his qualification is 7 years as an advocate or pleader. With this, other than district judges also, Article 234 says, what it says, other than district judges means the judges below the cadre of district judge. Who are they? We discussed earlier about subordinate courts, senior civil judges, or magistrates, civil or criminal side, and their cadre is called junior civil judge. They will be appointed by whom? By the governor of the state, in accordance with the rules made by him. So governor of the state means the state government will make rules. How he does it? He does it in that behalf after consultation with the State Public Service Commission and with the High Court exercising jurisdiction in relation to such state. So public service, State Public Service Commissioner and High Court both have to be consulted by the governor and must be appointed as per the rules made by the state government. Then who has to have control over the subordinate courts? Article 235 says, the control over district courts and courts subordinate thereto, including the posting and promotion of and the grant of leave to persons belonging to the judicial service of the state and holding any post inferior to the post of district judge shall be vested with the High Court. It is the High Court. Though appointing authority is the governor, posting and control and promotion power is with the High Court, not with the governor. So with this, we understand about how the Supreme Court, High Court and district courts are established and how the judges are appointed and what are the qualifications required to be there for them and what are the powers of those courts, and also regarding expenses and salaries, and also about Supreme Court and High Court being the constitutional courts are having the power as a court of record and also the power to punish the persons who are guilty of the contempt of the said courts. Likewise, we also discussed about appointment of district judges and also other subordinate judges and about also their powers and qualifications and also who will have control over the subordinate judiciary in respect of appointments and promotions and transfers. With this, we have finished regarding appointments and establishment of courts. We have to discuss next class about direct practical functioning of the courts. For this, we need to discuss about the Code of Civil Procedure 1908 and the Code of Criminal Procedure 1973, and then about the Indian Penal Code 1860 and the Indian Evidence Act 1872. So please go through these 4 acts. Now, regarding the provisions of Constitution, we already discussed today and in last class. Regarding practical functioning of judicial side created or established courts, we can understand only if we understand the other laws, procedural laws. What are the procedural laws? The Code of Civil Procedure 1908. It deals with how a trial has to be conducted and judgment has to be given by the courts. When a litigant approaches the court to implement his civil side rights, which are of civil nature, then there is another Code of Criminal Procedure 1973. It deals with the criminal cases. What is the procedure for conducting trial and recording of evidence and punishing a person who is guilty of the committing of offenses prohibited by law? For these 2 procedural codes, unless you understand how to record the evidence, what is evidence, that is under the law, the Indian Evidence Act 1872, we will not be able to understand functioning of the judiciary practically. For this, we need time. We will have in the next class.
Okay, sir. Any doubts, children? Please note down all the points.
If any doubts is, unless they interact with me, they will not be able to understand it. Otherwise, it will be one-sided. Please raise the doubts, anybody. If you are having, you can ask me in Telugu also. Telugu, English, Hindi. I understand. If anybody is having doubt, please ask. If no doubts are there, it's okay. You can also, it is a recorded video. You can
go through it again. Yes.
They can go through it again. If any doubts are there, you can personally also call me.
Yes.
Or give it to madam, she will call.
Yes.
Okay.
Yeah.
I think nobody is having any doubt.
No, sir.
Hello?
It is
No,
clear,
sir.
sir. It is clear.
Okay, madam. I will leave, madam.
Thank you. Thank you very much, sir.
Welcome.
We will join again, children, so that there's no disturbance in Shyamala Ma'am's class. Let's join again.
Okay.